Good morning, everybody. Rob Bonta, California Attorney General here. I want to say thank you for joining me today and us today as I announce an important legal action we're taking to safeguard California's ability to provide essential services to crime victims, including those who may be undocumented. We're here today to take a stand to ensure that every Californian, regardless of immigration status, can receive the victim services they deserve, services that are fundamental to their safety and to their well-being. Our state has long been a leader in protecting the rights of survivors of crime and will continue to defend those rights, especially in the face of federal policies that threaten to undermine access to justice for vulnerable communities. This morning, I've joined a multi-state lawsuit against the U.S. Department of Justice's unlawful restrictions on federal grant funding, restrictions that prohibit the use of these funds for legal services for undocumented victims. These Victims of Crimes Act, also known as VOCA, grants and services training officers and prosecutors violence against women formula grant program fund crucial programs for survivors of domestic violence, of sexual assault, child abuse, human trafficking, and elder abuse. And at the very start of Domestic Violence Awareness Month, we face the reality that President Trump is moving to strip funding from organizations that support survivors of crime. We continue to make it clear we'll hold the Trump administration to account for actions that are unlawful and unjust, which is why today marks our 41st lawsuit in 36 weeks against the Trump administration. That is how often and how consistently the Trump administration has broken the law, 41 times in 36 weeks, harming California in the process. In July, the US DOJ announced that states wouldn't be able to access VOCA funds unless they agreed to broadly support and assist the U.S. Department of Homeland Security's immigration enforcement agenda. In August, our office brought a lawsuit with other states challenging these conditions on VOCA. After we filed this lawsuit, US DOJ announced that it was imposing a restriction across multiple US DOJ grants, including VOCA, that prohibits using grant funds for legal services to undocumented immigrants. This new condition threatens at least $94 million in current funding to California. So just under $100 million is what's at stake here for California, which in turn jeopardizes vital services like helping victims file police reports, seek compensation, provide emergency shelter and transitional housing assistance, access legal advocacy, and so much more at the exact moment when these survivors, these victims, are most vulnerable. Worse still, it would force state agencies and service providers into the impossible role of immigration enforcers, diverting scarce resources away from victim care and creating confusion and creating fear. We're here today to make sure that that does not happen. Our lawsuit argues that US DOJ's new restrictions, one, violate the spending clause of the US Constitution by applying conditions retroactively and without clear notice, that they are arbitrary and capricious in violation of the Administrative Procedures Act because the DOJ offered no meaningful justification for this abrupt change midstream, and that they don't hold up to long-standing federal regulations, which explicitly state that access to victim services doesn't depend on immigration status. These conditions aren't only unlawful, and they're unlawful in all of those ways I just stated, they are also reckless. They undermine the very mission of victim services to help survivors rebuild their lives and bring offenders to justice. Today, we're taking action to defend the rights of survivors of crime and to protect the funding that helps keep our communities safe. The stakes for California couldn't be higher. Last year alone, nearly 1 million Californians benefited from victim assistance funding. That support included legal advocacy, housing assistance, emergency financial aid, counseling, and medical care. If US DOJ's restrictions are allowed to stand, survivors could be forced into the shadows. Perpetrators could escape accountability, and communities across California could become less safe. Our service providers depend on these funds to continue their life saving work. We can't allow Washington to strip them away or dictate who deserves access to justice. We'll continue to fight to ensure that every Californian, regardless of their immigration status, has access to the full range of victim services they deserve. This lawsuit isn't just about fighting for funds, it's about fighting for fairness, equality, and the protection of vulnerable individuals in our state. We'll continue to work with our partners across the country to hold the federal government accountable and to ensure that California's law enforcement agencies and victim service providers can continue the critical work they do to protect our communities. Let me be clear, California will always stand up for the rights of its residents, especially those who are most vulnerable. Our priority at California DOJ remains the same, ensuring a fair and just system, one that upholds the rights of all victims. And I want to take a moment to thank the dedicated team in my office who've been working tirelessly to bring this lawsuit forward. They got us to this really important point today, and that team includes Christopher Tenorio, Lee Sherman, Luke Friedman, Brian Bilford, Jesse Basbaum, Joel Marrero, and Michael Newman. Thanks to a great team working overtime to deliver for the people of California. And before I take any questions, I will circle back at the end. I'll hand it over to the CEO of House of Ruth, Pat Bell.
Thank you, Attorney General Bonta. House of Ruth provides comprehensive services to all survivors of domestic violence, including 24-hour hotline, shelter, counseling, housing support, and legal advocacy. And we've been doing so for the past 48 years. As recipients of the DOJ grant Cal OES VOCA XL, we offer legal representation, assistance with domestic violence restraining orders, court accompaniment, legal clinics, consultation, and referrals to all survivors. We are deeply concerned with the recent restrictions on the usage of these funds for undocumented immigrants. When a survivor seeks safety and support, we don't ask their immigration status. We ask, how can we help you feel safe? What do you need to begin healing? Our mission and values are rooted in compassion, not exclusion. Violence does not discriminate, and our services should not either. Every survivor deserves access to our hotline, our counseling services, and legal support. Imagine being a mother and you're fleeing abuse, terrified for your children's safety, and you're being told by an advocate that you can no longer access legal support because of your immigration status. These restrictions don't just deny help, they create fear, silence, and isolation. They empower abusers who weaponize immigration status to control and threaten survivors. Both survivors and advocates have witnessed perpetrators exploit the fear of deportation. So survivors are faced with the difficult choice, safety or status. And quite often, they choose to stop showing up for services and remain at risk in the abusive relationship. Our advocates are trained to meet survivors with care and compassion. These restrictions make it more difficult to build trust. And when survivors are excluded, entire neighborhoods become less safe. If survivors feel unsafe coming forward, abusers remain free to harm others. We need policies that prioritize survivor safety, justice, and access to life-saving services, not create barriers and exclusion. Everyone deserves to feel safe. Thank you to Attorney General Bonta and your staff for continuing to support victims of crime and survivors of domestic violence.
Thank you. And next we have Mark Lee, CEO of Radiant Futures.
Thank you. Good morning, everyone. Again, my name is Mark Lee, CEO at Radiant Futures. We are a nonprofit that was founded back in 1976, which makes us the oldest domestic violence agency in Orange County, and we're the third oldest in the United States. So we have a very long history of providing our critical services to survivors of both domestic violence and human trafficking. And at Radiant Futures, we believe that safety and access to safety is a human right. No one should have to weigh their options in securing that safety between the fear from their intimate partner and the fear because of their immigration status. And when a survivor finally gets the courage to seek out and come to us for support, our main and only question to them should be, how can we help you? How can we keep you safe? And not ask about their immigration status. So when we turn someone away, or when we have to tell a survivor that they can't access our services because of their immigration status, we are forcing them to be in a very vulnerable state. We're also sending a very dangerous message to the people that cause harm, letting them know that right now is the time to take advantage and exploit the situation and cause more harm, knowing that their partner can't do anything about it. And that undermines the essence of safety. And because of that, the cycle of violence will just continue. That's why it is so important for us to continue our work and serve anybody who's been impacted by intimate partner violence, regardless of their status and regardless of their gender and sexual orientation. That's why we stand alongside with our community and the survivors in our community. We are standing alongside with our partners like House of Ruth, and we are standing alongside with leaders like Attorney General Bonta to ensure that every survivor has the right to safety. Thank you.
Thank you. And thank you, Mark, and thank you, Pat. We can take questions now, if any, from the press.
If you'd like to ask a question, you may do so by clicking on the raise hand icon at the bottom of your screen or through the Q&A feature. First question comes from Aton. You are now unmuted.
All right. Thank you so much. First of all, to Mark and Pat, thank you for your time, and to the Attorney General. I know it's the second time this week you're doing this and taking questions. Really, really appreciate that. Now, Mr. Attorney General, this is a very important story. There's certainly reporting on this tonight, but got to also ask you on the government shutdown here. Just hearing a few moments ago from the White House press secretary that there are at least it's on the table that there could be an undisclosed number of layoffs of federal workers. In a way, it's kind of related, not totally, but to kind of your lawsuits trying to protect federal funding and layoffs. Of course, only Congress and the president can strike a deal to end the shutdown. But what, if any, legal action can or even will you take to respond to the shutdown?
So just to be clear here, the shutdown totally belongs to Trump and the Trump administration. He is in the White House. His party has the majority in both houses. They have the trifecta, and the federal government is shutting down when they have the trifecta, when they are in the majority in both houses and run the White House. This is their shutdown. They own it, and they're responsible for it. That's item number one. Item number two is that they need to figure out a pathway, and Trump needs to be reasonable in what he does to make sure that critical, essential federal services are able to be provided and that the federal government operates. This is the second time and that we had a major federal shutdown, and the last time it was on Trump's watch too. So, you draw the connection and the through line here. When Trump is in office, we have federal shutdowns, and it's a problem, and he needs to do better. He's the leader for all of the United States of America. And so we will do what we always do. We will review for illegality what the federal administration does at this time. We don't have a planned or anticipated or imminent action when it comes to the federal shutdown. It's for Trump to figure out and to get the government working again. But I am disappointed in the fact that there is a shutdown. There shouldn't be. A responsible leader should not have a shutdown, and Trump owns it. And to the extent people are going to get hurt by the shutdown, that is avoidable, that belongs to Trump.
Thank you, Attorney General. Thanks, guys.
Next question comes from Kevin. You are now unmuted.
Thank you. Earlier this week, you were talking about litigating a shift in cuts to disaster and anti-terrorism funding from being conditioned and then from being just sort of shifted by your contention to red states. This litigation follows separate litigation about mandating states follow immigration policy in order to receive VOCA funds, and now this is a slightly different lawsuit on similar funds, right? So I think in both instances, you are litigating doubly on similar or the same funds as the administration has shifted its approach to limiting the funds. Can you talk about having to do that, having to fight multiple legal battles around similar funding, and what you make of the administration's willingness to slightly shift its approach to go after similar funds, even when it's been sort of pushed back in a similar but slightly different legal setting?
Yes, and thank you for pointing that out. We talked about this a couple days ago in our press conference where it was round two on Department of Homeland Security funding that was initially conditioned upon an unlawful cooperation on immigration enforcement term, and then they just overnight redistributed the funding away from basically blue states or states that have a pro-public safety, pro-immigrant trust policy, and towards red states that don't have that policy is what it appeared. And I think I told you then we beat them before, we're going to beat them again, and now I'm here to tell you we beat them again. We got an order immediately. We filed on the day that you and I spoke, and we had the press conference, and we got a temporary restraining order the next day, blocking for the second time the unlawful action of the Trump administration. So this follows that same pattern. They took an unlawful action with respect to victims funding, and then they're taking a second unlawful action with respect to the victim funding. And we believe that the results will be the same here with respect to VOCA funding, victim funding, that it was for the Department of Homeland Security funding that was, and FEMA funding that was for counterterrorism and disaster relief and emergency preparedness and cybersecurity. So, but to your point, it is, I've always said it shouldn't be a lot to ask that the President of the United States of America follow the law and comply with the Constitution. And perhaps when they are brought to court and a court order indicates that they've broken the law, they probably shouldn't do it again. And I don't think that's a lot to ask either, but yet they do. And so we are required, and we're duty bound and I believe obligated to make sure we see this through. You can't be that you take an action or held accountable, a court finds that you've acted unlawfully, and then you just take another unlawful action to try to restrict or withhold that same funding. When we're in, we're in for a penny, in for a pound. We're in all the way to stop the unlawful action when it occurs. And this is what they did. I think I mentioned this last time with the OMB funding. They tried to do, and this is our second lawsuit. They tried to withhold $3 trillion nationwide, $168 billion in California, of funding that covered a whole wide variety of areas that are funded from healthcare to housing to food to college, childcare, et cetera. And we won. We blocked that withholding of funding. It was illegal. And then they proceeded to attempt in different ways to withhold funding that was a subset of that broader 168 billion. And we continue to beat them as well. But it is not something that you should have to see, that a federal government, a president of the United States is so contemptuous of the rule of law and is willing to break it and break it again, get told by a court that they're violating the law, and then have to be told by a court again. So we believe that the same results will be secured here, that we will once again defeat the Trump administration. We've been winning over 90% of the time when it comes to our restraining orders, and we expect to win again here.
Thank you. Next question comes from Kate. You're now unmuted.
Hi there, thank you. I'm Kate Wolf with the Sacramento Bee. I understand that this states were notified of this change in July. I'm just wondering, like, what could happen to organizations that are providing these services? Are there impacts already being felt?
I don't know if Mark or Pat want to chime in on any impacts that you might be feeling on the ground.
We haven't seen any direct funding cuts yet, but the restriction of, submitting requests for funding reimbursement and having those requests kicked back because they're unallowable, that presents a real challenge to us in having to discern, just serving everyone. Everyone deserves to receive the same services, and for us to be kind of forced into a position where we have to screen makes it extremely challenging for us.
And I just want to quickly add that we are already seeing a lot of the fear from our undocumented survivors with the rhetoric of the news and also with the ICE raids that they're seeing in their community throughout the recent months. So we are actually seeing a drop in the number of hotline calls to our number, and people are not coming to seek safety in our shelter and our housing program. So even without this funding cut as of now, we're still seeing the negative impact because of what's going on with the rhetoric.
Yeah, and I just want to make sure that I clarify that this is our second lawsuit, as Kevin's question pointed to, on a similar a body of funding. And we brought a lawsuit in August after a condition was placed that we believe was unlawful on the funding back in July. That lawsuit is pending, and we believe that we're going to prevail in that case. And then after we brought our lawsuit in August, this new term on existing grants, so changing the condition on grants midstream, was attempted to be imposed upon the grants. And so we brought our second suit for that unlawful imposition on grants midstream. And for the reasons I've stated earlier, the spending clause, the Administrative Procedures Act, the contrary to law nature of the action, we believe that it's an unlawful imposition on the grants midstream.
Thank you.
Next question comes from Michael. You are now unmuted.
Good morning, everyone. Michael Zinstein with Cal Matters. I have two questions, sorry. Question number one, Attorney General Bonta, have you begun presenting cases to the Court of Federal Claims ever since the SCOTUS decision in the NIH case? And will this be the kind of suit that may have to go before the Court of Federal Claims, since it's a existing funding question?
What's your second question? I'll answer them both at the same time.
The second question is for either Pat Bell and Mark Lee.
Okay.
And it's walk us through just how cumbersome, difficult, or impossible it is to confirm someone's citizenship status, residency status, vis-a-vis access to this money.
So let me try to answer your first question first, and then I'll let Mark and Pat chime in as they wish on any aspect I think is appropriate to answer for that question. But the Court of Federal Claims, of course, the U.S. Supreme Court's guidance, their decisions are ones that we will always follow. We follow court orders. The U.S. Supreme Court is the highest court in the land, and so we are evaluating their decision based on when a case is appropriate to go to a Court of Federal Claims. We still believe that there are times consistent with their guidance when it's appropriate to go to district court, like this case, which is in the District Court of Rhode Island, like the prior case on VOCA funding and that improper immigration condition, which is also in federal district court. But we will follow their guidance. We've been reviewing it. We've been discussing it internally. We know it's governing law, and we will bring cases to the Court of Federal Claims as appropriate, consistent with the U.S. Supreme Court's guidance. I also want to say that I made a point earlier to your second question, which Mark and Pat can add to, that this attempt to impose this condition, which again we believe is unlawful, and we believe it will be struck down and not implemented ultimately. But it puts service providers who don't look at immigration status. They look at, are you a victim? Are you a survivor? Have you been abused? Have you been assaulted? Are you in need of help? And how can we help? It puts them in a very difficult position to be immigration enforcement officers instead of doing what they do best and what they should be doing and what the regulations when it comes to victim funding say they should be doing, which is not inquire about immigration status, inquire about whether you are a victim, and then provide you appropriate victim services. So that's my answer to your question to Mark and Pat, but I'll let Mark and Pat jump in as well.
Mark, do you want to take this one?
I mean, Attorney General Bonta, you just said it. You took the words out of my mouth, and I think I have nothing more to add. But that is really the case for us at Radiant Futures.
Thanks, y'all.
That was the final question.
With great appreciation for Mark and Pat, thank you for all you do for victims that you serve in California. You shouldn't have to be dealing with attacks from the federal administration on your ability to serve victims and help survivors recover and heal. And we're going to do our best to make sure that you don't have to deal with that, and that we protect you and protect the funding that you deserve to serve victims. Thank you to the press for joining us today. As we announced yet another lawsuit, unfortunately, against a consistently and brazenly lawless and law-breaking federal administration. We're always going to fight for upholding the rule of law, and everyone is subject to the rule of law, including, yes, the President of the United States. So thank you for joining us to hear about this case, and look forward to seeing you again next time.